thank you to ChIPs for all that you do for us as a community. Can you hear me okay? Can I get a thumbs up from somebody? Okay, we're going to go with that. Okay, so we have a short period of time, but hopefully an exciting presentation to give you, something a little bit different, a little, hopefully going to keep you awake at the beginning of the morning if you're on the West Coast of the United States, or in the middle of hitting your lunch hour. So we all know that, so the team of care providers that you have today will be talking to you about some of the tough IP issues that are happening within our global economy that are challenging and give us headaches, or set our hair on fire, or however you'd like to describe that. So if we could go to the next slide. So we're going to be covering a few different things today. One, introductions of your care providers. Two, we'll be talking about global IP and US export control issues, which is an issue that is near and dear to my heart. And then Angela Freeman will be talking to us about European Unitary Patents and the Unified Patent Court, which is a hot topic and something that we all need to be paying attention to. And then finally, Deborah Pollack-Milgate will be talking to us about our ground rules with regards to global litigation as we are moving back into full force on a global community and economy. So next slide. So let me introduce you to our care providers. So to be fair, your care providing team actually likes to have a little bit of fun with things. So there are some winks and nods with regards to this to try and keep us all awake. But I can tell you that these are the best practitioners in their particular fields. Deborah Pollack-Milgate, for example, is probably the person that I would say is our team lead with regards to our firm, with regards to our ChIPs engagement. And for that, I am so grateful to have her as partner. Angela Freeman, likewise, is an amazing practitioner also in patents. Angela and I are more on the portfolio, prosecution and management side, and Deborah is more on the litigation side. I am the head of our patent practice group within our firm, which is Barnes and Thornburg. We're about 700 attorneys for a general practice firm, but we have a very large IP practice, well over 150 practitioners, of which a large majority of them are actually registered patent attorneys, which makes us a little bit of an unusual group to providing care for you today. 22 offices, AmLaw 76, that's the end of my commercial. Let's go to the next slide. So for the purposes of today, in order for us to not make anybody feel uncomfortable about how our fact patterns and our discussions line up with maybe particular aspects of your own company, we've made up one. So the name of the company is ACME, American Chemistry, Mining, and Energy. Let's say for our purposes that their headquarters in Chicago, which is a lovely place to visit since the 1930s. And they have business divisions and subsidiaries and affiliated companies all over the world. And we've used those particular terms specifically because complex corporate structure is an issue for a lot of for each one of these subject matters that we're going to be covering. Additionally, ACME has R&D centers in the US, Germany, China, India, and the UK, probably much like yourselves. And the corporate structure is, as I said, rather complex, with some commercial sectors organized under the ACME name. So for instance, ACME Health or ACME Mining or the like, and then completely different terms and names associated with certain brands. And additionally, there is an issue as to whether or not some of these companies have standalone business support platforms and some of them are sharing business support platforms. So when I say business support platforms, I mean all of the company requirements, say for instance, legal. So there may be, in ACME, there are a number of different companies that are all sharing the same legal staff, but they are separate corporations or subsidiaries or affiliates using those services. Whereas perhaps a couple of different subdivisions or subsidiaries were acquired and decided to keep their own legal team and keep a number of different corporate associated issues. This becomes an issue for us because it does affect the way that we practice and some of these issues that we're going to be talking about today. So as an aside, one of the things that I need to tell you a little bit about what's happened with Acme historically. Historically, their work was in chemicals and energy, but that's evolved into product lines and service offerings, including, and I'm being very specific, but it'll be important. Say, for instance, ceramic composite materials that are equally useful in both aerospace and also alternative energy. Also, they do some battery cell technology for electric cars and drones and low Earth satellites. And they do a number of different areas that could potentially make their technology portfolio very interesting and different ways to handle. Also, over time, healthcare actually has surpassed mining as an area of focus of that company. And they've become a market leader in staple materials for pharmaceutical and healthcare industries, especially after COVID. So at some point in time, there was a decision they had a conversation about whether or not to change the M in Acme to H for healthcare. I'm gonna wait for it. That would spell ACHE, which was summarily dismissed. Thank the Lord. And so now they are still Acme, but they use the acronym universally, and they try to just avoid the fact that they're not really necessarily an American company, they're a multinational company, and the mining not so much. So we're going to, as we proceed through our discussions, we're going to be holding our questions until the end, but feel free to put them in the chat so that we can treat them as they come along organically. So let's go to the next slide. So as I said, this is one of the areas that's very near and dear to my heart. I'm a patent practitioner, but I do work with global multinational corporations. And what we have happen is that we realize that there are these things called US export controls, which perhaps you have seen in the news at various different times. And they do have an effect on how we share and interact with our clients, with our customers, with our vendors, and also with our employees and contractors who are not necessarily in the United States or might be not US citizens. So we're going to be talking about that first, and then we'll talk a little bit about, to rehash the global reality of innovation and inspiration. As you know, viruses do not generally pay attention to border crossings, and luckily innovation and collaboration also does not. And that actually works to our favor as long as we manage how we communicate. And then we'll have a little bit of a discussion about pain management. So next slide. Great. All right, so for those of you who don't know what export controls are, in the United States, an export control is basically a set of laws and regulations that restricts the export or re-export of goods, services, or technologies to protect US national security. We can implement foreign policy, we can talk about what that really means, or maintaining regional stability and the like. And so what happens is, in order for those rules and regulations to be complied with, US companies, facilities, and individuals are required to obtain a license or other authorization prior to releasing what is called controlled US origin technology to foreign persons outside the US, including what we talk about as intra-company releases. So we are talking about the situation where we're exchanging information within our own company. If we're talking about foreign persons outside the US or even foreign persons in the United States, there are things that we need to look at. And so sometimes we need to get a license from the government for something like that, and a license or other authorization for non-US nationals, as I said, in the US to access controlled US origin technology. We also may be restricted from dealing with other non-US parties in a proposed transaction. You may have seen that in the news happen from time to time. I'm not going to mention any names, but there are definitely a few that have shown up. Prohibited from involvement in transactions in certain countries, and also prohibited from complying with certain specific boycott terms in the Middle Eastern contracts. We're not going to get into that last one so much today, but let's go to the next slide. It's worth noting that There are two types of export controls that we deal with on a regular basis. One is export administration regulations, those are EARs, and the other one is at the bottom. These are international traffic and arms regulations, so they're referred to as ITAR. So there are a number of different US government organizations that are involved, relative US agencies. It's usually the Department of Commerce, which is the Bureau of Industry and Security, the US Department of Treasury, which is the Office of Foreign Assets Control, and the US Department of State. And so that would be the Directorate of Defense Trade Controls. Also, the US Department of Defense gets involved with regards to Defense Security Technology Administration. And then from time to time, we also see the Department of Homeland Security chime in, the Department of Justice, and also National Security Agency. So this is a very dense slide, and I will try and pare it down as much as I can. So EAR, the Export Administration Regulations, they control export and re-export of what are called commercial items and dual-use products in certain technology areas that are controlled under the Commerce Control List. So everything that is listed on the Commerce Control List gets what's called an Export Classification Control Number. And it's kind of like, I think the best way to describe it is, it's a huge encyclopedia of technology. And you have, the first thing you have to do is figure out where your technology or your product falls into this encyclopedia to understand whether or not it's controlled or not. And that's really important. And so some of you may be thinking, what the heck is dual use? I would say that an example of dual use would be, say, for instance, I was talking about Acme's ceramic coating. And so there would be potential use, say, for instance, with regards to alternative energy and wind farm blades, you know, those gigantic things you see as you're driving from point A to point B in the United States. But they also have an aspect that may be particularly valuable with regards to aerospace that has defense implications as well. So when we have technology that is controlled for the purpose, because it has a military aspect, and then we have it also has a commercial aspect, that is something that we have to look at. With that, let's go to the next slide. Great. So in short, how to explain why this is particularly important. So the US government, so speaking for myself, the first time I dealt with in-house patent counsel on this topic, we said, you know, these are important things. You have IP that you're trying to protect. You have people who are working on multinational teams who are developing that intellectual property. And then perhaps you may have a whole group of people who are in legal who are all over the world, and some of them may not be US citizens. And so the situation occurs that, for example, if an invention disclosure form comes in and the group of people that have to look at it have people on there who are not US citizens, that is something that can potentially trigger US export control problems. And we'll get into how you deal with a situation like that in a couple of slides. There are mechanisms for dealing with it. It is not an insurmountable task, although it can seem that way when you first start, especially because I'm going to tell you all the reasons why it's really important to pay attention right now. So the US government can impose monetary penalties against individual employees and also against companies. And those individual employees can be subject to imprisonment. You don't want that to happen to anybody who's on this call or anybody you know. And so having a mechanism and setup and system and plan in place for how to deal with these situations is particularly helpful. But the penalties can be extreme. So administrative penalties against the business can include suspension or denial of export privileges. So if you're sending things outside the United States, they can stop those things from leaving, and that's huge. Also, to the extent that your company might have contracts with the US government, they can lose those if they're not paying attention to export control regulations. Additionally, there are monetary penalties and potential infringement. So these are not small numbers. So for an EAR violation, it can be $250,000 per violation, and it's not uncommon for us to have multiple violations. ITAR, which is more significant because we're talking about international traffic in arms, can be $500,000 per violation. Then with regards to criminal, those are the civil penalties. Criminal penalties, EAR $1 million also, and 20 years of imprisonment, and ITAR $1 million per violation or 20 years of imprisonment. Super scary stuff. And we want to avoid that. So, you know, I know this is we're talking about medical and we're talking about headaches, but I can tell you that this is like going to the dentist and having the dental hygienist tell you these are all the reasons why you have to floss. So with that, next slide. So I get this a lot whenever we start talking to our clients about this. And to be clear, I am a patent person, but I work with a whole bunch. We have one of the most amazing trade teams, I would say, of any law firm. And so I've been working with them consistently over the last 15 years, working for multinational corporations and companies that have a multinational footprint. And these are the things that people always say. They say, but wait a second, we don't really export anything. You know, we're a software as a service company. And so that's when we have to talk to you about something that's called a deemed export. So a deemed export is what's called an export, but it's of technology. It covers transfers of technology within the US or to a foreign national. And it applies to all transfers under EAR and ITAR. And in those situations, the export license or other authorization may be required. And so if we could go to the next slide. So what happens, how does a deemed export occur? Well, so we're going to use the word release. It's not a sexy word, but that's the word that they use in the regulations, so I have to use it. Release of technology, technical data, or source code to a foreign national. Visual inspection of equipment and facilities, verbal exchanges of technology, much like when two inventors are coordinating and thinking about how an invention will actually evolve and what it needs to look like, or what the next step is in a product line. Electronic transfers and facsimile transmissions, application to situations abroad of personal knowledge of technical experience acquired in the US. Oftentimes, like when an inventor goes to speak at a paper conference, and maybe they didn't get the paper cleared by legal before they walked out the door. Similarly, posting regulated technology on the internet, or even a company intranet, and that language is right there, intranet, not the internet. So it can even be something that is available and accessible to foreign nationals within your company's proprietary area. So next slide. There's a lot on this slide. I'm going to let you read it, but these are the kind of things that we're talking about that constitute exported technology. It's not just things in boxes that get on ships and go places. It could be as simple as meetings with non-US persons regarding controlled technology, telephone calls, remote access to software and technical data on US servers. Say, for instance, if you were to keep your invention disclosure forms on an accessible intranet area within your company, emails to non-US persons, website access, documents and samples hand carried by US travelers, it goes on. And if you see the forms of technologies, it really does run the range. What we're talking about is we're talking about the tools of technology, blueprints, training, know-how, specifications, formulae. Next slide. So these are the facts. Can't get around it. Fiber is good for you. Drink lots of water. Don't drink a lot of alcohol. Discussions in between US and non-US persons can constitute an export. They can also constitute an export if your discussions outside the US. Joint collaboration for new innovations can be considered to be an export. An evaluation of non-US persons of those innovations can likewise. Again, this is rather more obvious. Product manufacturer is the same way. And we also have to look at US domestic transactions if non-US persons are involved. So the goal here is to recognize and anticipate ahead of time the situations that can cause the headaches associated with US export control problems. Next slide. This is my last slide. So this is what I would tell you. The first thing to do for pain management is to consult with your export compliance officer. Even if you think you don't have one, you might. It would be good to go to lunch and just sit down and explain what your position is and what your job title is, how it works, the things you have to do, because you should have a dialogue with them. They can help you. If you don't have an export compliance officer, you can reach out to us. We can help you find something. There's lots of training that's available. You can build them in-house. That's how I started even before I became a patent attorney. But the first thing you're going to do with them is you're going to analyze the controls on the company's technology and the technical data. Because at the end of the day, bubblegum is not a controlled technology. However, adhesives associated and binders associated with those that end up going into ceramic composites, maybe. And so you need to figure out how to split your portfolio out in a way that you effectively manage and have an export compliance program for the controlled stuff and let the other stuff organically move along its way. And so you're going to want to have an export compliance program that you have documented, because if the US government comes and has some questions, it's 99% of the way there. If you sit there and tell them, here's our procedure, this is how we follow it, and that goes a long way. We also want to, for IP purposes, and this is important for the next couple of slides with regards to the rest of the group, to secure intra-company databases and files to protect against unintended releases of control technology. And also, I just have to throw this out for the rest of the world. Please know that the rest of the world also has export controls. And so if you are a multinational company, you should be having discussions. Your export control compliance officer should have counterpart relationships with them. So with that, I'm going to turn everything over to Angela Freeman, who's going to talk about something that's not maybe so scary, but is rather immediate. So could we have our next slide for Angela?
Christine, there is one question if you want to address it before we move on.
Sure, I can do it.
Sure. There is a question about whether employees actually have been imprisoned under these rules for breaking export control laws.
So the answer is yes.
I was afraid you were going to say that.
Yes, the answer is that yes. Generally, the reason why we have laws is because people have broken them and people continue to break them.
Fair enough.
That's pretty egregious. It's generally not a benign neglect kind of situation. There are shenanigans generally associated with imprisonment, but it does happen.
All right, thank you, Christine. So with that, I'm going to take over. I'm Angela B. Freeman. Nice to meet everyone, and thank you all for joining us. And I'm going to talk about today the European Unitary Patent and the Unified Patent Court. And as Christine mentioned, this is pretty imminent, so we wanted to get this in front of you in case you haven't heard about it, although I suspect you all certainly should have. The Unitary Patent and the Unified Patent Court are the primary pieces of reform in recent history to centralize the European patent system, particularly for enforcement and validity actions. And while the work to centralize this patent protection in Europe began over a decade ago, the final steps to its implementation occurred in February when Germany ratified the Unified Patent Court Agreement. This new system, and while we will harp on this, and you'll hear this repeatedly, this new system begins on June 1st, 2023, so next month, less than a month away, and will have a major impact on both how Acme, our fictitious company that Christine has introduced you to, as well as your existing applications, current patents, future patent strategies, and portfolios, particularly within Europe. So again, we wanted to get this information in front of you in order to relieve any pain that you may feel over the next several days while you still have time to act. Today, I'm going to briefly give you an overview of the coverage and the cost that Acme and other companies should consider with regard to obtaining a unitary patent, as one size definitely does not fit all strategies and all needs. I'll discuss additional practical considerations for ACME and others as to whether you should potentially opt out of this new regime, the Unitary Patent and the Unified Patent Court, particularly in light of central invalidation and enforcement opportunities. And then finally, I'll give you a bit of updated information about the status of the judicial personnel in the courts that are anticipated to be under the regime of the Unified Patent Court as it's set to open in June. Next slide. So as depicted on the left should be a regime that most of us are familiar with. This is our current patent regime in Europe that, again, should be fairly familiar. Each national patent application or a single European patent application is filed, and once that European patent is granted, that European patent may be validated in up to about 38 or 39 member states, plus about 6 or so validation and extension states. And each of those national or validated European patents are individually enforced in their respective national court and may stand or fall individually pursuant to any holding or decision of each of those national courts. This new system, which is kind of depicted on the right, is the new centralized European Unitary Patent System, which will allow owners like ACME to obtain a single unitary patent that will have effect in multiple European countries instead of individual patents for each country as is currently allowed under the current system. Additionally, this new regime establishes the Unified Patent Court that will have jurisdiction to resolve, again, validity and enforcement disputes under the unitary patent, and for some UP eligible European patents that may be held into the Unified Patent Court, which we'll discuss a bit later. Sammy, please, next slide, please. So I want to give you an idea of the coverage that the unitary patent will assume currently, because it's not straightforward. And while the concept of a single unitary patent that covers multiple European jurisdictions is quite appealing to ACME, unfortunately, it's not that simple. Because a current unitary patent doesn't cover all European countries or jurisdictions, which frankly, as a U.S. practitioner, makes my head hurt, which is part of why we came up with the name of this presentation today. There are additional considerations with regard to coverage of the unitary patent that are important for ACME and your company as you consider your commercial and business strategy for patent protection in Europe. Importantly, countries that are protected by a unitary patent and will be under the jurisdiction of the Unified Patent Court must be member states of the European Union. So non-EU member states are not eligible or ineligible for protection under a unitary patent in the UPC. And one of the most notable of those countries is the United Kingdom, as well as the 6 or so validation and extension states like Morocco or Bosnia. So this is a big consideration for ACME, who Christine originally mentioned has a large R&D center with many inventors in the United Kingdom. So inherently, we know that ACME is not going to be able to only use the unitary patent system because they have a whole R&D European state where they do most of their R&D that won't be under that regime. So that's important to remember. Additionally, EU countries that have not signed the UPC or the Unified Patent Court Agreement are ineligible to practice within this regime. That will include countries like Spain, Poland, and Croatia. So again, if you have major commercial practices or businesses there, this may be something you want to consider. But right now, there are about 17 EU countries that have signed the UP and UPC agreement and have ratified the UPC agreement. And these countries include France, Italy, Netherlands, Belgium, and others. and importantly, Germany, which was the country that its ratification really instituted the UPC in February to begin in June. That really was the country that got us in this position where now the court is actually getting ready to open. And so those 17 are the only countries where patent proprietors who obtain a unitary patent would actually have coverage and would be under the jurisdiction of the Unified Patent Court. Again, this has great implications for Acme, who has smaller but a very active R&D facility in Germany, and therefore those inventions would be under the jurisdiction or could be under the jurisdiction of the UP and the UPC. And then finally, there are another 7 countries that have actually signed on to the UPC and the UP, but haven't actually ratified the Unified Patent Court Agreement. So coverage for those countries is expected to grow over time to up to about 24 or 25 European countries and these individual countries, once they ratify it under the enhanced cooperation of the unitary patent, these would be the 24 to 25 countries that ultimately will have coverage and protection under the unitary patent and will be under the jurisdiction of the Unified Patent Court. So ratification of that UPC agreement by these 7 or so countries is really important to note for you all and our Acme company, and something to watch, because what that means is there are going to be different generations of coverage or protection under a unitary patent and under the Unified Patent Court. Again, this is particularly important for Acme, who's looking to potentially build a manufacturing site in Ireland. And I think I saw someone from Ireland on the call today. Ireland would be an important commercial venue for Acme, but it hasn't yet ratified the UPC. So that coverage, and when Ireland ratifies the UPC, may have real implications for when Acme determines it may be beneficial or not beneficial to actually take advantage of the unitary patent and or the Unified Patent Court. Next slide. So one of the biggest considerations for the whole regime is the cost. Cost is always important for any company when considering patent procurement, and Acme is no different. And one of the major considerations that I'm trying to demonstrate here is that in addition to the renewal fees, or in addition to the validation, the filing and validation fees that we know are required for any European patent, the renewal fees are something that you can get a little more comparable comparison between a European patent and a unitary patent. And based on the comparisons that are shown, it's demonstrated that a unitary patent will be significantly less expensive than a European patent that's validated and maintained in 4 or more countries. So consequently, the more countries a classic European patent would need to be validated in, the more cost effective is a unitary patent over the course of the life of the patent. Now, accordingly, if you plan to file protection for patent protection in 4 or more European countries that are actually part of the UP or UPC, it may be more economical for you to file a unitary patent than to validate in those 4 or more countries. However, cost, again, is not the only consideration regarding patent strategy when considering this European patent versus the unitary patent. Since, again, for companies like Acme, they will have no choice but to file for European patents in addition to any unitary patent coverage, since, again, their largest R&D facility is in the United Kingdom, which won't have protection under the UPC or a UP at all. Next slide. So again, for the next 27 days, we're going to be in the remaining period of the sunrise period, which is really established 3 months ago and goes up into the UP and UPC go into effect on June 1st. And so we'll still be under the old European patent validation system where directly filed EP national applications or EP validated applications will be under the respective national jurisdiction of the national court jurisdiction, as shown at the top of the slide in that kind of schematic. For these EP patents that are currently being allowed, it is important for you to know that during this sunrise period, you can request a delay of grant of any European patents that are getting granted now in order to file a request for them to have unitary effect, or basically to be a unitary patent with coverage under the 17 countries that I just mentioned previously. But as depicted on the slide at the lower half, or the lower bottom of the slide, under the future UPC and UP system, an applicant or patent owner like Acme will be able to file a direct EP national application that, when it's issued, will be under the jurisdiction of the national court. That's what's happening now, along with any EP patents that are in non-UPC countries, like UK, as I mentioned. And then Acme will also have the option to file for a unitary patent that will have exclusive jurisdiction under the Unified Patent Court, which we talked about. Additionally, they could file for a European patent that may be outside or opted out of the default UP or UPC system during examination, but still is elected later to be opted in and or adjudicated by the Unified Patent Court later after issuance. Therefore, this UP and UPC system will have jurisdiction over all unitary patents and all EP validated applications in UPC countries that are not opted out. So everyone will have to deal with this in some respect, which is why we wanted to get this in front of you early, because this is something that everyone's going to have to deal with in due course. Next slide. So again, June 1st is our date. Starting June 1st will be the first opportunity to obtain that unitary patent. And there is an unextendable due date that falls 1 month from the mention of the grant of the European patent in the European Patent Bulletin. So 1 month after the publication of the grant is when you have a hard deadline to file the request for unitary effect if you want your patent issued under that regime. So that's an important date. Now, to request that unitary patent or this unitary effect, a few things are needed. Of course, the patent number. The requester of the unitary patent must be a proprietor that is mentioned on the European Patent Register at the date of filing the request or at the date of registration of the effect. So what that means is the person, the entity requesting the unitary patent must agree and align with the entity that's actually on the EPO's records, and that's important. And then finally, the common representative must be a member of the UPC state. And that's important because if you have co-owners of a patent where one is a member of the UPC state and one is not, then it is important that the entity that actually is a member of the UPC state is the entity that requests that unitary effect. Otherwise, there will be problems. In addition to those three requirements, the language of the request of unitary effect needs to be the same as the language of the proceedings, and translations must be provided. One English translation and one official one translation in an official European language, which historically in the old EP system has been French or German, and that would be perfectly fine here as well. So that's how you or Acme will request a unitary patent. And it should be noted that this, while the system is beginning in June, there's going to be a transitional period before it becomes the overall law of the land. And that transitional period may last from 7 years up to about 14 years. So starting June 2030, this will be UPC will be the law of the land. And in the interim, between now or June 1st, and then we'll have kind of this mixed jurisdiction. And I just want to talk about that briefly. Next slide, Sammy. This mixed jurisdiction will be in place between, as I mentioned, the initiation of the UPC starting June 1st and this 7 to 14-year transitional period. The mixed jurisdiction will allow your company as well as ACME to kind of play both sides of the fence. You'll have the opportunity to use the current EP system where EP national applications will be in the EP national court, as well as the UP and the UPC system. So again, specifically for ACME, we'll have the choice to have EP validated patents in UPC states, either adjudicated by the UPC, by the United Patent Court, or by the EP national court. So there'll be a little bit of flexibility there. Non-UPC countries or non-UPC EP validated patents will only be adjudicated in national court. So basically, if you're in an EP national court that's a non-UPC country, you'll be in the EP national court. Again, all unitary patents will be under the exclusive jurisdiction of the Unified Patent Court, and that's the only opportunity there. But again, during this mixed jurisdiction, during the transitional period, applicants like ACME will have the ability to do a few things. It will allow ACME and other patent owners the opportunity to potentially select lower value inventions that may be protected by the unitary patent and then possibly litigated under the Unified Patent Court in order to begin building this judicial history of the Unified Patent Court. Part of the challenge now is no one knows how this court is going to rule, so everybody's a little hesitant. But as more entities, more companies begin putting patents in their regime as by either selecting a unitary patent or selecting patents to be adjudicated in the UPC, will get more judicial history. So again, this becomes important for a company like ACME when selecting some maybe of its lower valued invention that may be derived in its German research facility that would be under the jurisdiction of the UPC to begin building this judicial landscape for future engagement by more and more entities. Next slide, Sammy. So as the job of many attorneys in the IP space, the attorneys of ACME are also faced now with making some really hard decisions in light of the UPC and UPC system without having a lot of concrete information. And I don't know about any of you all, and I don't know if you all have ever heard this term, but my parents used to call me hard-headed all the time, which means you're stubborn. And that's kind of the same regime as some of these decisions that you'll now have to make with regard to either getting involved with the UP and UPC or not, without having a lot of history and knowledge in which to base such decisions. So I just wanted to kind of walk through some of the advantages and disadvantages, at least that are currently known, to help you make some of this decision. For example, some of the advantages we've talked about are cost related. There are no additional costs to register the UP at the EPO. You get broader coverage of all 17 countries initially, again, up to 24 or 25, for the cost of renewals of about 4 countries. There are reduced costs for some translations since you have reduced requirements there. And it's less costly to do a central revocation or have a central platform to bring infringement actions. A little aside from the cost of the cost perspective is that many of the UPC judges have been deemed to be some of the most experienced practitioners in Europe. So, I mean, that may weigh into your decision making if you know some of the judges, or they may have been practitioners at your firm in which you have a relationship who have now been deemed to be some of these judges. That may weigh whether you want to go into a UPC jurisdiction or not. Again, some of the disadvantages, of getting into the UP or UPC system straight away is just, again, the uncertainty and the high risk of the legal outcome of the court, just in light of the fact that we don't have a record in which to determine how they may rule. Another major concern about this whole centralized platform is that the high risk of validity challenges and the risk of central revocation of full patent families. So again, unlike our European system where national applications rise and fall individually, you now under the UPC have the opportunity to have a whole patent family, at least those in UPC countries, revoked on one ruling. And certainly for applicants and patent owners like Acme that have broad coverage over Europe, that becomes a very scary opportunity. Again, higher annuity costs if you have more than 4 countries, so that's something to consider. There's no current opportunity to get coverage of all EU member states under this UP and UPC regime, which is going to mean that companies like Acme, who have a facility in UK, are always going to have to fall outside of that metric, which may, weigh on how beneficial the whole regime is for you. And then finally, as I mentioned already, you can't opt out or partially opt out of the UPC. All the rights rise or fall together. And again, that can be a great opportunity or a very scary premise, depending on your coverage and where you're located. So, again, one of the biggest concerns right now is this opportunity that, your patents, your European patents, can be held into the Unified Patent Court without you having even any knowledge of that initially. And so that, for a lot of people, means that opting out of this regime may be a preferable option. Next slide. So if you're a patent owner like Acme that's not quite certain, you're not quite convinced as to whether this is going to be beneficial for your company and for your patent strategy or not, one of the ways to kind of mitigate that risk is to do what we're calling a opt-out, an initial opt-out, where you opt your patent applications and your patents out of the UPC system until, again, there's a little more feel of how the court may rule, et cetera. Okay, I'm wrapping up. One opportunity to opt out is to affirmatively do so. And what's important about that is that the actual proprietor of the application needs to be the person who opts out, whether that is what is on the books of the EPO or not. And that's very important. So now spend time getting your ownership information in order so that you know who that is and who can properly file that opt-out. Next slide, Sammy. I'm going to speed through these. Just a few points. I've already mentioned these. Things that you can be thinking about now or doing to stay ahead of the June 1st date. Request delay of grants for any applications that you think may want to go into the UP. Ascertain, again, all eligible applications so you know what's eligible and has protection and not. If you already know you're interested in the UP, you can go ahead and file early requests to do that as long as the records for the proper owner are aligned at the EPO. And again, confirm those records, confirm the assignee, and then file any necessary opt-out, preferably before June 1st, just to be on the safe side. Finally, I just want to talk about the patent court very briefly as I give it to Deborah Pollock-Milgate. What's most important here, and I won't go into too much information, is that there are a few courts of first instance. The local and the regional divisional courts are really where you're going to bring your infringement actions. And that's important because, again, those infringement actions can be asserted where the infringement is occurring or is threatened to occur or any place of business of the defendant. And then there's the central division where most of the revocation actions. Of course, the Court of Appeal is always available, and then if necessary, the Supreme Court of Europe, which is the Court of Justice of European Union. And with that, I'm going to hand it off to my partner, Deborah Pollock-Milgate.
Hi, everyone. Good afternoon. I'm Deborah, and I've been working in global litigation for about 20 years now. And if your head doesn't hurt yet, I'm here to contribute to that. I do have to say, I find it really funny when Christine says that export controls are near and dear to her heart. Shocking that Angela was stubborn as a child. So we've had all kinds of revelations today. And also, I just like to, since I am someone who's suffered from headaches for a couple decades now, I will tell you my best headache hack has been, shout out to Eli Lilly. They have a new drug called Emgality, which I've started to take, and it has pretty much wiped my headaches out. So if you're there from Eli Lilly, thanks for that. It's much appreciated. Okay, global litigation. I just have a few minutes here to make your head hurt even worse. And so I'll try to do that. Although what we are really trying to do is saying, listen, you can take these really difficult topics and then break them down into manageable bite-sized nuggets. The last thing you want to do is stick your head in the sand. So that's obviously our job as lawyers, is to make sure that our clients are not sticking their heads in the sand. So that's what we're trying to do also with respect to ACME. So first and foremost, when you're involved in global litigation, you absolutely have to leave all of your assumptions behind. We often, as US litigators, if you're a US litigator, as I am, you have a certain understanding about how everything is going to proceed. And you expect that certain things are going to be different when you're in a foreign jurisdiction. But you don't really expect everything that's going to be different in a foreign jurisdiction. So some of these things that I have on this list on this first slide are fairly obvious. The issues that are going to be decided and where. Most of you probably know on this call that in the US system, we're going to look at infringement and we're going to look at invalidity at the same time if we're talking about a patent case. If we're in Europe, however, the most common fact pattern is going to be that you are going to be looking at those issues individually. There's going to be a court in Germany in particular, where ACME has been before and is now. There's going to be a court that determines infringement and another court that determines invalidity. We know that much, but then there are some other complications that come up along the way where it's really important that you are talking to everyone. For example, something as silly as, I guess it's not silly, but in the US on the burden of proof, we don't always take that seriously because it's just a standard that has to be applied. But with respect to infringement and invalidity, the difference in the burden of proof in the United States can make a huge difference. So for invalidity, you have to prove it by clear and convincing evidence. Infringement, it's only a preponderance of the evidence. So when ACME, when the European attorneys talk about, we don't have a problem in the United States because the patent's invalid, you have to kind of slow down with them and walk them through the proposition that there are different burdens of proof, and it's much more likely that you're going to be found to infringe. And this invalidity defense that you have, which may work better in Germany, is not going to work as well in the United States. So these are all of the assumptions that we really have to talk about to make sure everybody is absolutely on the page. And by the way, we've got a language barrier. Oftentimes, we've also got a culture barrier, so that even when we think we've spoken to each other in a way that's direct and that makes sense, we may or may not have accomplished our goal. Some other things that are just, have come up, just a couple of examples that ACME has encountered over time. It's been surprised, for example, in litigation in India, that once it wanted to actually settle litigation, it wasn't automatically able to do that. Again, in the United States, we assume no problem, no harm, no foul. We initiate litigation, we can always take it back, or usually take it back. That's not the same all across the world. Let's go ahead and move on to the next slide, because I think some of these other things will be obvious over time. So by comparison, and I will just say it, our colleagues in Europe, in ACME, they hate US litigation. They just do. And we need to know that as the US company, that our colleagues in Europe are unhappy with US litigation. These are the things they hate. They hate discovery. They don't by any means ever want to open their corporate records. They don't like jury trials. They think that's about the stupidest thing they've ever heard of. I hope I'm not exaggerating. I don't really think I am. Then there's this problem of US litigation being incredibly expensive. Not only that, in the Europe, where the attorney's fees go to the prevailing party, in the US, we're going to carry our own attorney's fees. And so what does that mean for them? What that means for them is this is going to be a very expensive process. Then there's a very important point with respect to injunctive relief versus damages. Injunctive relief in the US system, when it comes to patent infringement, is very, very difficult to obtain. And that is something, if you're coming in from the European perspective, that you may not be expecting. Because again, our clients in Germany, it's fairly easy in Germany, if there's some kind of an infringement, to get injunctive relief. In the United States, that's not going to occur. And then we have some other things here as well that Europeans are not super excited about. That's this whole notion of willful infringement. That's also this threat of inequitable conduct. So next slide. I think what I'd like to do, because I know that we are very close on time, is I'd like to talk just a little bit about the attorney-client privilege. And then I'd like to give you just my 30-second summary on what an intracompany agreement is. And if you take one thing away from this presentation today, it should be, if you don't have an intracompany agreement or an intercompany agreement, you should. But let me step back for a moment on the attorney-client privilege. This is another really important aspect when you're dealing with a company that is a global institution like Acme. It's really hard in a global institution to maintain the attorney-client privilege. That's something that can easily be compromised because the communication styles vary very much from one jurisdiction to the other. And importantly, the patent agent privilege is unlikely to be applicable in US litigation. It is very unlikely. Now, we know our friends, again, at Acme in the UK, and especially in Germany, they like to vet a lot of the infringement issues that come up. They like to do that on their own, and they're really good at it. The only problem is if we want to rely on that in a court of law in the United States, or if we have to produce documents in discovery, those communications about what they think about a particular patent and whether they're going to infringe or not, they're likely to be discoverable. So you have to have some communication protocol in place for the entire organization so that you are able to protect those vital privileges when it comes to US litigation at a minimum. So let's skip along a little bit here, Sammy, and let's get to the intracompany agreement. So I want to talk just very briefly about that. So with the intercompany agreement, as I was thinking about this, just to describe what this is and what you need and why you need it, the intercompany agreement is really a way, it's kind of your agreement to end all agreements in the context of IP. So it is a joint development agreement, it's a confidentiality agreement, it's a license agreement. It is all of these agreements put into one place where you are managing IP and the flow of IP within an organization. And what you're going to have to do as part of that is think about, is there a fairly simple way to put a structure in place that makes sure we are protecting all of our IP within the organization? We have all of our licenses in the right place. We have all of our R&D flowing in a coordinated manner. And this is really difficult when it comes to a company like Acme, because they have different research outfits and they have different counsel and they have different decision makers. So they've got a lot of pieces to put together to try to figure out how they make sense of that. But there absolutely has to be a clear decision-making tree with respect to IP, and you're going to have to weigh the autonomy versus your ease of administration. You want it to mimic, if you can, you need it to mimic the way the organization already operates, but then sometimes that's not always possible. So you have to be a little bit flexible at the same time. The last point that I really want to make, if we keep going through here, is one other point that I would just like to highlight in context with the intercompany agreement there's a lot of important elements of this, but where I really don't want people to lose sight of the intercompany agreement is in the context of trade secrets. You have to remember that all of these organizations are separate organizations. And by the way, in litigation, we like to respect the corporate form, right? When you get hailed into court, you don't want to have to provide the documents for every organization within that subset of organizations that in this case is the ACME agreement. So you absolutely have to have confidentiality agreements in place between those companies so that they are sharing what they need to share to do business. And on the other hand, that they are all under the umbrella of trade secret protection. That's an element that ACME has not always been great at, especially as new organizations come in under its umbrella. It hasn't been great in paying attention to that. So super important with respect to confidentiality and trade secrets. So I'd like to thank you all very much for joining us today. I know that was a lot, and I'm very thankful for my colleagues that I don't have to remember everything that they delivered today, because it's a lot. So thank you, and thank you to ChIPs, because I love being part of this group.
Likewise. So Deborah, really quick, if I could just summarize with regards to Barnes and Thornburg. So there's this old adage that says, every doctor always says, take 2 aspirin and call me in the morning. And the reason why they say that, in case you haven't figured it out, is because lots of people go to the doctor and the doctor thinks this isn't really a big issue. It'll resolve itself. If you don't feel well, you can call me back. We are not saying that these are these kinds of situations. These are really hard. And so we love talking about them. Reach out to us, have conversations with your colleagues. These are important and they will make your brain hurt. So this is more than a 2 aspirin approach. So thank you.
Thank you all.
Oh, I see we have some text from ChIPs chapters listing some of the really great opportunities we have for more community. I think that I speak for my firm in that we will be making these slides available to everyone who has participated, so that for your continued use. And we hope that you have a really great morning and afternoon.